Well, happy Thursday to you, everybody. Bill O'Leary coming to you live here on this. Boy, we were into November, November 4th, 2021. And anyway, I'm coming to you live, and it's part of our Thirsty Thursday series. For those that may be coming across this for the first time, I'm an estate and elder law attorney, and my firm is Legacy Planning Law Group, and so we handle estates and trusts and wills and that sort of thing. And so what we've been doing for some time now is coming live every Thursday at about this same time to talk about a topic that may sort of something maybe we've come across in the office or I've read about or whatnot that relates to wills, trusts, and estates and probate and all that good stuff. So we call it our Thirsty Thursday series. So if you're thirsting for knowledge, you have come to the right place. So, what is today's topic? This comes up a lot. A power of attorney. What decisions do you need to make when putting together a power of attorney? Okay, so look, a power of attorney can seem like a simple, really like a simple document, but there's several important decisions that you have to make when you're creating one. For example, who you're going to appoint and what powers are you going to give to the person that you're appointing as your power of attorney. So a power of attorney is one of the most important sort of estate planning documents you can have. It allows the person that you appoint, what we call your agent, sometimes it's called your attorney in fact, but I like the term agent, where your agent can act in your place for financial reasons and for financial type purposes. And that usually is helpful even if, when you become incapacitated or you can't manage your own affairs anymore. Although a power of attorney in Florida is effective right away, usually it's most helpful and useful when someone starts to have declining health. Now, the power of attorney can permit your agent, to do things like pay your bills, make investment decisions, do planning for you, and basically take care of the family when you can't do so anymore yourself. So, some of the important things to consider, some decisions that you'll have to make when putting together a power of attorney. The first thing to consider is, who do you appoint? Who the heck do you appoint as your agent? Look, you need to appoint someone that you trust and somebody that has your best interest in mind. Sometimes that's easy. For other people, that's not so easy to think of someone that sort of fits that description. The person also needs to be organized and responsible and have the time available to do this, or at least be able to make the time available to do this. What is this? Really to carry out the functions that are being given to them. Paying bills, guiding investments, handling any legal matters that may arise, talking to financial institutions, and so forth. So generally, people appoint family members to this role, but sometimes none of the relatives are suitable or would be a good fit. So in that situation, you may want to consider appointing a friend, or even like an accountant, or an attorney, or even a clergy person, somebody, maybe your minister. If there's no one to appoint, and you don't end up doing a power of attorney because you don't have anybody that comes to mind, then when you get to the point where you're incapacitated, somebody is going to have to go down to court on your behalf and open up a guardianship case. So that's exactly what a power of attorney is designed to prevent, getting involved in the court system. So that's the first thing to consider, who you're going to appoint. The next thing to think about is, how many agents do you want to appoint? You can appoint one or more agents on your power of attorney. Having multiple agents allows more than one person, to share this responsibility, and it allows them to sort of, divvy up the tasks. If you appoint more than one, be careful. Make sure that the power of attorney document allows each agent to act on his or her own, requiring them to act together. Yes, it's a good thing. It provides checks and balances, but it's really impractical and cumbersome in the real world, because your agents are going to have to sign, every check or other document. So again, it becomes quite impractical. Also, if you appoint more than one agent, make sure they get along and they're able to communicate, because if not, misunderstandings can develop. So frankly, in my view, it's generally better not to name more than two agents. But maybe if parents have three children, well, they don't want any of them to be left out. So what some attorneys will do is prepare two separate powers of attorney, naming separate agents rather than having the one power of attorney naming both agents together. So that's one way you could go. But the problem with that approach is that anyone dealing with either agent may not know that the other power of attorney document exists, and that may discourage sort of communication between the agents. So the question of how many agents. How about alternates, naming backups, okay? So instead of naming multiple agents to serve together as co-agents, you can name one or more alternates in case the first person that you name or that you appoint as your agent, if they can't serve. Maybe they passed away, they're incapacitated, or maybe they just don't want to do it. So, for instance, you can name your spouse as your agent and let's say your children as your alternates. Now, if you do name alternates, make sure the document is very clear about when the alternate is going to take over and what sort of evidence the alternate is going to need when presenting the power of attorney. Otherwise, a bank, think about it, a bank or a financial institution might deny access to the account if the bank isn't quite sure that that this alternate now has taken over, if they're not sure sort of who they should be dealing with. So for this reason, it may be better to appoint multiple agents rather than one and then an alternate. So again, there's no right or wrong answer, and that's something you really ought to talk through with your planning attorney. So again, it's avoid sort of any question of proof when the second agent steps in. What about the issue of gifting? Well, a power of attorney usually will go on for several pages listing the various powers that the agent that are given to the agent and the powers that they can sort of carry out. This is because financial institutions and tax authorities and the like often look for and frankly demand specific authorization for the power to make a gift. Okay? Well, why would you want your agent to have that power? Okay? Well, look, you may say on the one hand, I don't want to give my agent the power to make gifts. When I'm incapacitated, I don't want that agent to be gifting away my money because, hey, I want to keep that money. But if you are sort of the mindset that you would want to make gifts if you were of sound mind, you might want your agent to be able to continue doing that. If you've been supporting children or grandchildren, or you would anticipate doing that in the future, but at that point you're not able to do so anymore, you may want your agent to be able to do that on your behalf, okay? So often you see that the power of attorney forms, they limit these gifts to a certain amount, $15,000, maybe you've heard of that, that's sort of what we call the annual gift tax exclusion, okay? So you may want to limit an agent's sort of gifting power to that $15,000 limit. So the issue of gifting is something to consider. What about the issue of trust powers? Okay, if you have a trust, you want to give your agent the power over your trust. So similar to making gifts, it can be important to authorize your agent to make a new trust, maybe amend an existing trust, or to be able to fund an existing trust, put assets into the existing trust that you have. So the power of attorney forms that are out there often permit the funding of pre-existing trusts, but don't allow their modification or of a trust or the creation of a new trust. So these powers can be extremely important in the context of long-term care planning, also in the context of asset protection planning or special needs planning. If you have a spouse or child, grandchild with special needs, very important that the power of attorney sort of be broad enough and comprehensive enough to allow your agent to deal with your trust in that way. And then the last thing I would sort of commend to you to think about is what about copies of the power of attorney and how to store it. So once the agents and the wording of the power of attorney have been determined, so you decided who and sort of the wording of it, how many originals should you have and where should they go? Okay? Most power of attorney documents include language that say that a copy should be treated just like an original. So if a copy is presented to a bank and whatnot, that they should treat it just as they would the original. But this is not always honored by third parties, even though it may say it very plainly. In addition, an original may be inaccessible for some period of time. So, as a case in point, if there's a transaction involving real estate where the power of attorney is used, a lot of times that original power of attorney has to be recorded with the deed. And so, yeah, at some point the power of attorney is going to be returned, okay, by the local, government, but it may not happen for several months. So, one option is to execute several original powers of attorney. The attorney can keep one, and then the client can take two, let's say. So maybe consider doing 3 originals. You have the option to keep the originals yourself, or you can give them to your agents. I prefer that the client keep the original and give copies to the agent. So usually people keep the originals and tell their agents where the documents are located, just in case they're needed. One other important consideration is to see if any of the financial institutions where you have accounts, maybe they have their own power of attorney form. So if that's the case, make sure to execute their forms in addition to the one that you've put together, just sort of as a hedge in case they refuse your power of attorney and insist on their form, although they're not allowed to do that under the law. It happens in the real world, okay? So, if you would like to know more about the things to consider when creating a power of attorney and maybe would like to know how we can help, we'd love to talk to you. So, I encourage people to go ahead and set up a free 15-minute phone call. We call it our discovery phone call. You can do it very easily on the Facebook page. Go to the Book Now button, or just go ahead and Google us, Legacy Planning Law Group. Okay? So hey, if you've enjoyed this video, please like it. Better yet, please share it with your friends. So I hope you've enjoyed this talk, decisions to consider when making a power of attorney. Again, next Thursday at about the same time, I plan on giving the same talk. Same day, same time for the most part, just a different talk. So if you're thirsty for knowledge, we will quench your thirst. So Bill O'Leary signing off for now. Hope everybody has a great rest of the week and a great weekend. And on behalf of everybody here at Team Legacy, go make it a great day and a better world.